And by the way, another tactic that the left is using is saying, well, abortion is gone. That is not true.
Hmm.
All we are doing now is making this a states' rights issue, which gives the people and our democracy more ability to flourish. So this doesn't mean that abortion is gone. In places like California, New York, Illinois, very liberal states, there will probably be infanticide. And that will have the repercussions that it shall. But other states, yes, that are more conservative, the people will choose, their electorate will choose, the legislature will choose. So that's sort of a bastardization of the law and of what this opinion means. All it means is that Roe is not good law. And by the way, brilliant liberal jurists like Ruth Bader Ginsburg even said that Roe wasn't good law. Lawrence Tribe, a brilliant attorney and strategist in the legal realm, said it wasn't good law because what it did is it put the ability for the Supreme Court to have to make every decision about abortion. Let's leave it to the people and let's leave it to the states. It doesn't belong with 9 people in robes. It
Yeah.
belongs to the electorate in our
Yeah.
democracy.
Amidst all the noise in the aftermath of the Supreme Court striking down Roe versus Wade, you've probably heard people on the right say that Roe was a singularly unconvincing ruling in the first place and decided on very shaky legal ground. It's what this Newsmax host says right here. And I want to dive deeper into this discussion for crucially important reasons that aren't really popular on the left to talk about, especially right now. Because within this discussion lies how the pro-choice movement can win back the right to abortion. So this claim about Roe being settled on shaky ground is absolutely true. Ruth Bader Ginsburg herself acknowledged that a woman's right to make decisions about her own body was not best exemplified by the ruling in Roe versus Wade. And this is important, but not only is it just an interesting historical fact, but this is the future of how women can regain their bodily autonomy after having it taken away from the Supreme Court. So Ginsburg thought the better way of approaching the issue of abortion would have been the Equal Protection Clause of the 14th Amendment rather than the Privacy Clause, which is what Roe is ultimately settled on. And she was actually representing an abortion case on its way to the Supreme Court when Roe was decided. She knew that that case that she was representing would have been far stronger than Roe was in codifying abortion rights. Terry Canfield, a legal scholar, summarized the case on Twitter, writing that Ginsburg was handling a case for a client named Susan Struck, who was in the Air Force when she got pregnant. Oddly enough, at the time, abortion was not only legal in the Air Force, but she was given a choice: get an abortion or get out of the Air Force. The catch? She was Catholic and didn't want an abortion. So Ginsburg argued in front of the court that an Air Force captain should not be forced to choose between an abortion and her job. And this would have been a bombshell way of opening a dialogue with the Supreme Court about a woman's right to control her own reproductive organs. Ginsburg then wanted to argue that Struck could not be mandated to have an abortion because it should be a woman's choice. Her appeal was filed in 1972, but as we know, Roe reached the court just after that. RBG openly regretted that her case didn't arrive first because she knew it was stronger than Roe. She worried that the sweeping nature of Roe versus Wade would trigger a backlash. And boy, was she right. In her confirmation hearing, Ginsburg said that, quote, "It is essential to women's equality with man that she be the decision maker, that her choice be controlling. If you impose restrictions that impede that choice, you are disadvantaging her because of her sex." So here we see RBG underlining her argument that the right to choose should be based on the constitutional basis of equal protection under the law, not, as it was codified in Roe, by a privacy clause. She then clarified, saying that, quote, "Abortion prohibition by the state, however, controls women and denies them full autonomy and full equality with men." And again, she was working on a case that would have argued that. This is hugely important as we face the next stage of this fight, because it is this question, the only question pro-choicers really need to be asking right now. How are they going to get abortion back as a constitutional right? And make no mistake, this is a long game, a 40-year plan, just like the right had. Roe versus Wade is gone. There's no use in prolonging our mourning of the specific case, which legal scholars across the political spectrum agree wasn't rock solid. This is what we need to be asking ourselves. Where does the fight go now? And what does tomorrow look like? Thanks so much for watching. You can follow me on all platforms at Caro Johnson 917.